because now there will be a new deputy president, and we sued Honorable Rigathi Gachagua when he was the sitting deputy president, as a deputy president, not as Honorable Rigathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014 on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, just 1 minute. Again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you're overtaken by events, just like some councils were trying to say. That's all. Thank you.
Thank you.
Your Lordship, for the third petitioner.
Sorry, my Lord, I was to take cue. My name is Sam Nyaberi. You gave indications and directions earlier that we take 2 minutes. I wish to call upon Waithera, who was on her feet before, so that I donate my time to her in the spirit of nurturing young talent, and so that she can also raise a fee note to be paid.
Ms. Waithera, how are you?
I'm fine, thank you, my lord.
You have been donated time, so take it and make your submissions.
Thank you, my senior Mr. Nyaberi. My name is Wanjiko Waithera for the 9th petitioner. And taking off from where my senior Mr. Wamboi left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have the applications dismissed on account that Parliament has the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKLR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts, as defenders and protectors of the Constitution, have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my ladies, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my lady, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles of this country. Thank you.
Thank you.
My Lord, having had that, we organized Ms. Omari will do a wrap for 30 seconds or 1 minute.
I hope you meant 30 seconds.
My Lord, I didn't want to talk, except that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number two, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency levels. Can that be the position that this court will uphold? I beg that the court extends the grant of the conservative orders. Thank you very much, my lords and my lady.
Thank you.
Your Lordship and my lady, my name is Sakimpa. For the third petitioner, we'll be sharing time with my colleague, Mr. Wathuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by my learned seniors, so I'll only put into context in our petition. Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion, I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory